And thanks for joining us again on the program. I am Nifemi Oguntoye. On March 6, 2025, the Senate suspended Senator Natasha Akpoti-Uduaghan for 6 months. That suspension that should have ended on 4th September 2025. But instead of a return, she reportedly received a letter from the acting clerk of the National Assembly saying her resumption cannot be processed while the case is still before the Court of Appeal. That stance has ignited national controversy. Civil society groups call it undemocratic. Afenifere says it reeks of pettiness. And the NLC has threatened mass protest if she is denied her seat. At stake are not just the rights of one senator, but the integrity of our democratic institutions. Joining me on Beyond the Headlines this hour are two men at the heart of this legal and political standoff. Senior Advocate of Nigeria, Monday Oyekachi-Ubani, Special Advisor on Legal Matters to the Senate President, Godswill Akpabio, while Tijani Jimoh is a member of Senator Akpoti-Uduaghan's legal team. Gentlemen, thank you both for joining me to help put this in perspective. Let's begin with you, Mr. Jimoh. Walk us through the clerk's letter dated 4th of September. What really does it say? And is there any basis for delaying resumption beyond the 6 months?
Good evening, Mr. Oguntoye, and thank you very much for having me. So,
go ahead, Mr. Jimoh, I can hear you.
As regards the... Yes, please. As regards the letter sent by the acting clerk of the Senate to Senator Akpoti-Uduaghan, with the greatest respect to the office of the clerk, the position taken therein by the office of the clerk was clearly misconceived, and there is no basis whatsoever upon which she may be denied entry into the Senate to resume her functions and to resume her duties as a legislator. Because when you read that letter, what you see is a selective application and distortion of what the principle of sub judice entails. Sub judice is not a bar. When they say a matter is sub judice, okay, sub judice is meant to restrict parliamentary debates on matters which are before the courts. However, with regards Senator Natasha's suspension, there is no debate whatsoever to be heard. The Senate considered, quote and unquote, what they considered misconduct and found, albeit in breach of a subsisting court order, and suspended her for the 6 months period, which has now come and gone.
But Mr. Jimoh,
the issue before the court at this...
Let me just jump in quickly. What exactly is before the Court of Appeal? Who appealed on what grounds and what issues are being contested?
Okay, so there are a number of appeals before the Court of Appeal. The Senate had appealed the judgment of the Federal High Court. The Senate President, Godswill Akpabio, also filed an appeal, and Senator Akpoti also filed an appeal. So there's an appeal and there are cross appeals pending before the Court of Appeal.
Let me bring in the senior advocate into this conversation. He is the special advisor on legal matters to the Senate President. Mr. Bani, thank you for joining us on the program. Let's hear from you. What's the legal foundation for the Senate's insistence that Senator Akpoti-Uduaghan cannot resume until the Court of Appeal decides? Mr. Bani, can you point us to any constitutional provision or standing order that actually supports the Senate's insistence that the senator cannot resume until the Court of Appeal decides?
Which Senate? Has there been any response formally by the Senate was the Senate ever written by Senator Akpoti that she wants to resume, and the Senate has responded to that? I don't know. Can you point out any response by the Senate to Akpoti? Is there any response from the Senate?
Is the Senate denouncing the purported letter written by the acting clerk, Senior Advocate?
It's not a question of denouncing. The proper procedure, which I think the lawyers of Senator Akpoti should be advised, is that they should do the right thing. The letter should have been addressed to the leadership of the Senate, and that is the chairman of the National Assembly, the Senate President. Or in the alternative, there are lawyers who are in this particular matter that is in court, both at the lower court and the Court of Appeal. They should have addressed the letter to the lawyers representing the parties in the matter, saying, look, the 6 months suspension has actually expired, is about expiring, that they want to ensure that the woman resumes, upon a lapse of, whenever the Senate resumes. Presently, the Senate is on recess. I hope you are aware of that.
To resume on the 24th of September, Senior Advocate, what I was referring to really is the clerk's letter that cites sub judice. Just a minute, sir. That cites sub judice because the Federal High Court already seemed to have ruled against the suspension. Shouldn't the Senate comply with the judgment?
I don't understand. Which court ruled against suspension? Which of the courts?
Well, the court in some way or the other appealed to the Senate to allow the distinguished resume duty.
You are talking about an appeal and also asked them to review their rules. There was no judgment. That's what we've been saying all along. That actually what happened in Senator Natasha's matter was that she was invited by the Ethics Committee, if you remember, to appear because of issue of misconduct that was alleged. And she rushed to court in order to challenge that invitation. While that invitation was lingering, and she was suspended. She never in any way amended her pleadings in order to reflect the suspension. She was still attacking the issue of the invitation and also attacking the fact that she was not allowed to speak from the seat she was, trying to air her grievances. Why not going to the proper seat that was allocated to her? That was what the court decided. And all the matters were resolved against her and all that. So when you say there was a favorable judgment by the court, there was no such judgment.
But that's the point I'm making, Senior Advocate, that the position of the High Court was such that the Senate should allow Senator Akpoti to resume. If that is the position of the court, why is the acting clerk now giving sub judice as an excuse for not allowing her to resume?
Can I answer your question? What I'm saying is that the Senate presently is on recess. Immediately, the Senate resumes. Every matter that pertains to Natasha's resumption will be dealt with. And I can assure you that the Senate that is actually a Senate of law that respects the rule of law, we told the line of legality in addressing our issue. I don't think that we are only trying to hit up the politics. There is no reason for all this that is occupying the space. We have more important issue to discuss about our nation. There is issue of insecurity, there is issue of economic issue, and not issue of Natasha. 2 months ago, it was Natasha every day and all that. We are going back to that same thing and all because the woman wants to be in the news all the time. And she likes it. She craves it and then try to paint the institution she wants to go and, be a representative, in the bad light. The Senate is on recess and immediately the Senate resumes. The issue of Natasha will be dealt with and we move on as a nation and all that. So the Senate is on recess presently. So there is nowhere the Senate will want to toe the line of illegality and all that. They will look at it and address the issue. This issue of eating the polity and Natasha occupying the space is what she desires. And we are giving vent to it. We don't want that to happen.
Allow me to bring in Mr. Jimo for a minute and then I'll be back to you. The bone of contention has been the letter written by the acting clerk, which was specific as to whether or not the distinguished senator will be allowed to resume on the expiration of a suspension, and that letter did make reference to sub judice, and that was the issue I raised earlier. But Mr. Jimo, legally speaking, if suspension expired on September 4, does the senator have an automatic right to resume? If so, what steps is your team taking to enforce that right?
Sorry, Mr. Oguntoye, can you take that again?
Well, I'm asking that if the suspension expires on 4th of September, does she automatically resumes? And what step is your team taking to enforce that right?
Okay, thank you very much. Yes, with the expiration of the appeal, that gives her the strongest legal footing. At that point, they are no longer debating whether or not the suspension was illegal. She is simply saying, I have been punished. She can raise a plea of outre convict. She has served her punishment, and at that point, there is no bar whatsoever There is nothing stopping her from resuming her duties immediately. The Senate had considered the situation, handed down a sentence. That time has come and gone, and at that point, and at this point, presently speaking, there is nothing whatsoever standing in the way of her resumption.
But some say that this stalemate could drag on for months. Is your principal willing to withdraw the case in court, at least temporarily, to allow for a political solution and immediate resumption, especially in the interest of our constituents who have been voiceless for 6 months now?
Yes, the last hope of the common man, as they always say, is the courts. Sadly, the good people of Kogi Central have had to be in the last 6 months without any representation at the Senate, sadly. And because of the constitutional issues agitating therein in the appeal pending, a political solution would not lay this matter to rest effectively, because when you look at the precedents over the years, this is not the first case of suspension. The law is clear, and this continues to happen. So when you say a political solution, what good would we be doing? We're hopeful that the Court of Appeal would decisively deal with this issue and put an end to this once and for all. These are clear infractions of the law. The judgment of the Federal High Court, per my Lord Justice Binta Onyako, she held the suspension to be excessive and overreaching. When we say overreaching, what was it overreaching? It was overreaching the Constitution. And it is elementary constitutional law that when something is inconsistent with the Constitution, it is null and void to the extent of its inconsistency. Thank you.
Tijani Jimo, member of Senator Akpoti-Uduaghan's legal team, Monday Ubani, senior advocate of Nigeria, special advisor on legal matters to Senate President Godswill Akpabio. Gentlemen, please, we're going to go on a short break and then we'll return to this conversation. Stay with us, everyone. Gentlemen, thank you for staying the course on the show. I'm coming to you now, senior advocate. There is the political implication of this quagmire. Over 600,000 people in Kogi Central are currently without a senator. Does that bother the Senate? And is the institution of the Senate comfortable with what many now refer to disenfranchising them while this legal back and forth continues?
As I said earlier, the Senate is a lawful institution. It's an institution where members from various states of the Federation come to represent their constituents and are interested in effective representation by members. But that does not stop a member who has committed an infraction from being punished in accordance with their standing rules. If you remember that a court itself approved of that suspension and said there is nothing illegal about it, what the court was only saying is that, review your rules in order to ensure that in terms of punishment, it does not in any way affect effective representation by any member who has actually offended offended any rules of the Senate. And so the issue of punishment is allowed, has been recognized by all the court's judgment, both in Ndume's matter and all other senators or House of Rep members that have been punished by law. There is evidence of the fact that court have always agreed that members can be punished. And then even in this particular instance, the court approved of it. But the issue of effective representation is what the Senate is interested that any member should in any way represent the people that have elected him or her to be at the particular Senate at any point in time. But where there is an infraction, it will not in any way affect the fact that that particular member ought to be punished. That is very important. And as I said earlier, she has served her sentence and all that. The Senate clearly is on recess. When they resume, they will look into this particular matter. And as I said earlier, they will toe the line of legality and the appropriate decision taken about her resumption in order to carry out her constitutional duty of effective representation of our constituents. And so we are only hitting the politics.
I hear you clearly. What some members of the civil society organized labor and opposition are saying is that she has served her time. She has been punished, that the letter from the acting clerk was not called for, making reference to sub judice. But critics also say that this matter could have been resolved politically rather than through protracted legalism. If Senator Akpoti-Uduaghan were to consider withdrawing the case, do you think Senate leadership will be open to an immediate reinstatement?
Yes, I will not be in a position to compel her to withdraw her matter. If she wants to have any matter addressed by way of court coming into addressing her grievance, is allowed in law. But the point is that, as you really pointed out, there is diplomacy in everything we do in life, you know, and she is a first-timer in the house. If things like this happen and they gave you an option, apologize and move on. I mean, it had happened to several senators, and they took that particular option. But she has a right not to. And say, I want to pursue my matter to a logical conclusion. It's her choice, you know. But I think if there is wisdom, and Bible says in all our getting, we must get it. You know, there are certain things that can be resolved without going this entire hog, you know, in pursuing legal matter, where leaders can come in, where elders can come in and say, what is the issue? And they sit down on a round table, and before you know, the matter is resolved. But if she chooses the path she's choosing and all that, good and fine for her. Nobody is going to stop her from doing that. But I think that it would have been better, you know, followed by diplomacy, by reaching out, and before you know, the matter is resolved, and an effective representation of our constituency should be a primary concern and all that, and not this issue of a protracted legal battle that can take many years. It can from the Court of Appeal, and anyone can lose, and then we now go to Supreme Court. Before you know it, the 4 years is all over and all that. So I would have loved a more practical approach that will actually bring this matter to a peaceful conclusion. But she chooses the path of fight. It's good and fine. Nobody is going to advise her. She has to advise herself. That is what I think, sir.
Let me bring in Mr. The spokesperson, a member of the Senator Natasha legal team, Mr. Jimo, into this conversation. You know that some civil groups argue that this case is bigger than the distinguished senator, that it's about whether the Senate can sideline court judgments and silence dissent. Do you worry that dragging this out could deepen political bad blood? We've talked about the impact it will have on our constituents, even if you eventually win in court.
All right, thank you. So, yes, the case, if you say it is bigger than the senator, firstly, there are a number of issues agitating in the appeal. There's the issue of a fine, which the court had fined the senator, and that is a quasi-criminal sentence, and that she has appealed as of right. So the appeal pending before the Court of Appeal goes beyond the immediate suspension. It goes beyond the immediate suspension. As regards whether the issue is bigger than the senator, there are very serious constitutional issues agitating in the appeal. The learned silk, the spokesperson to Senator Akpabio, had made some references that the courts had not held the suspension to be illegal, but the case now is, this is a very narrow case. The contention was never that the Senate does not have the power to suspend, but initially she went and challenged the process leading to her referral, which was in breach of her right to fair hearing, and the court did find that in her favor. Also, when you say the Senate has the power to discipline, Senate has the power to discipline, yes, but within the ambits of the law. Within the ambits of the law, the Legislative Powers, Houses, Powers and Privileges Act and the Senate Standing Rules provide a maximum of 14 days. This is a suspension running over about 180 days, about 10 times the legally allowed, the upper end of the limits allowed for a suspension. So it's not whether they have the right to suspend her, to discipline an erring member, but the process leading up to that. Yes, there are laws, and laws were meant to be obeyed and must be obeyed.
Mr.
And
Jimo.
it is very important that the court makes a pronouncement on this issue, because at the point where the Senate handed down the sentence on her, the Senate was functus officio at that point as regards punishing her, and there is no review to be made when the Senate comes from recess. It goes without saying. She has... Yes, please.
I just wanted to know what the update is with the sexual harassment case. Is it part of the issue you have appealed at the court? What is the current status as we speak?
Okay, thank you. The issue of sexual harassment is currently not before the court, as that was before the Senate Committee of Ethics and Privileges. However, the same committee of the Senate had, on the premise of sub judice, adjourned that petition sine die, and it does not currently form part of the appeal before the Court of Appeal.
Did the senator at any time had the opportunity to provide evidence, as she claimed earlier, before this committee?
No, because the committee has not proceeded to hear the matter, as it was adjourned sine die on the grounds of the matter being sub judice.
If she had an evidence, why didn't she go to court if she's not getting a chance to, prove her case with the committee? Why was this omitted from her grievance in court?
Yes, okay, thank you very much. As regards going to court, now, there are different subject matters, and the law provides a number of avenues which you can use to address your grievances. As a member of the House, the Senate has the Committee on Ethics and Privileges, and which also governs Code of Conduct. The petitioner and the respondent in this case are both members of the Senate, and there's nothing wrong with her taking that matter to the Senate Committee on Ethics, whilst the issue of her referral to the committee, which then led to her suspension, which breached some of her fundamental rights, was taken to the Federal High Court, which was the appropriate avenue to address that grievance.
You know that the issue of allegations of sexual harassment became a bone of contention that many Nigerians became highly interested in. If she didn't have a chance with the committee, many Nigerians would have thought that that should be one of the issues she should have raised in court, especially since she mentioned that she had evidence in that regard. But, Senior Advocate, let me come to you very quickly. This standoff has unleashed a barrage of attacks on the Senate itself. Afenifere calls it petty. Some are reporting that it's a dangerous precedent. And you've heard the NLC also threatening to march on the National Assembly if she's blocked from resuming. Does the Senate leadership appreciate the reputational damage? And do you think it's worth risking public unrest and institutional credibility over one suspension?
I need to address some of the things my learned colleague has said about the judgment at the Federal High Court before I address your last question. There was no
We have just about 2 minutes, sir.
Are you hearing me?
Yes, I said we have about 2 minutes, sir.
Okay, there was no time there was any favorable judgment concerning her invitation by the ethics. She rushed to court saying that her right of fair hearing was breached by that invitation, and the court held that there was no breach. The point is that she was invited. It is only when she goes to that particular listen that she can allege anything, if there is anything that happened at that particular panel. But you have been invited, and you have not even approached the panel, and you are now alleging breach. So the court held against her. So in all the things she actually asked the court to resolve in her favor, all of them, 4 of them were resolved against her, including some legal punishment, in paying fine and apologizing and all that. So the point must be clear to the legal team. And there was no time issue of suspension was before the court. What was before the court? The process of that invitation. And that is also what the Court of Appeal will decide. Now, concerning the question about reputational damage you mentioned, the point is this. Presently, the Senate, and I repeat, and I reiterate, the Senate is clearly on recess at this point. When they resume, the issue of Akpoti's resumption will be addressed by the leadership of the House, and there won't be any issue. The issue of anyone threatening, NLC has a lot of more things to do in terms of welfare of workers, rather than probably begin to now line up to go and say, calling Nigerians out to come and protest against Akpoti. Akpoti is only an individual. She's not the first senator to be in the Senate, and she won't be the last. So this issue of a first timer, causing so much chaos in the system and everyone is making her headline and all that, to me, it's of no consequence. The issue will be addressed by the leadership of the Senate. They are lawful. It's a lawful institution. They follow legality. They have not done anything wrong. She was not allowed to be resumed by the court. There was no time the court made any ruling. The court would have, the Senate would have obeyed if there was any such thing. And we are now on appeal on that issue. It was her that went on appeal, and then the Senate cross-appealed. It's important we also put that fact out that the Senate did not appeal first. She was the first person to go on appeal.
All right.
And the Senate had to cross-appeal. So it's important we put that out. So for the most important thing I want to say is that the Senate is a Senate of law. They follow the rule of law. And it's a highly respected institution. So there is no way they want to do anything that is illegal. At the fullness of time, when they resume, the issue of Akpoti will be addressed, and that will put to rest. The issue of NLC threatening and everyone threatening and all that. We are only hitting up the politics. The right thing will be done at the right time. And I'm putting it to you that the Senate is on recess. When they resume, the issue of Akpoti will be addressed.
Monday Bani, Special Advisor on Legal Matters to the Senate President, Gospel Akpabio, Senior Advocate of Nigeria, thank you for joining us. Tijani Jimo is a member of Senator Akpoti-Uduaghan's legal team. Gentlemen, thank you for joining us on the program. We'll continue this conversation subsequently. The distinguished senator is one out of about just 4 female senators. Critics say she served her punishment. All eyes on the Senate, just like the senior advocate said, when it resumes plenary, all eyes on the Senate as to the decision it will make in this very sensitive matter. Stay with us, everyone. We're back next week with more. I am Nifemi Oguntoye.